So let's move on to permanent residence in the United States, because I think that's what a lot of people, this is like when you're going to cross the finish line to be permanent residents, get that green card. And if you want to get a green card through your job as a physician, you're going to do it in one of two ways, either through something that we call PERM, which is about a year old, or through a National Interest Waiver. PERM used to be called labor certification, and that's where we advertise for your job in the newspapers and ask American physicians if they're qualified and available for the job. And you know, if you're working in an underserved area, there's nothing to worry about because you're not going to get a lot of American physicians who want to go there. If you're not in an underserved area, then we have to kind of look at the employment picture to see if you have any special skills that the Americans may not have. The other way is the National Interest Waiver, and I'd like to just give a little history of that because that's something I've personally been very involved in. We actually got Congress to pass a law back in 1999 saying that physicians who work for 5 years in an underserved area could get a green card without any of this advertising. It's called because they're serving the national interest of the United States. Unfortunately, in the year 2000, the Immigration Service, who obviously didn't like this law very much, came out with regulations that contradicted the law, which they're not really allowed to do that, but they do it anyway unless somebody challenges them. They get away with it. To give you an example, in the law it says all physicians can qualify for a National Interest Waiver, and in the regulations it says no specialist. Doesn't make a lot of sense. That's changing the law. It's not interpreting the law. So me being sort of the Don Quixote type, I decided I'm going to get a bunch of physicians through my webpage together. We got 8 physicians from Massachusetts, from Georgia, from Washington, from Oklahoma, from California, went into federal court, challenged the law. And a year and a half later, we lost. The district court judge said, Mr. Shusterman, are you saying that the Immigration Service can't promulgate regulations to interpret a law? And I said, no, that's not what I'm saying. But she ruled against me, and we went up on appeal, and it's called the Ninth Circuit Court of Appeals, where we had to appeal this. And if you go to my website, I actually have the oral arguments. We have to do 15-minute oral arguments before the court, and it happened on December 5th, 2005. And you will hear from the oral arguments that we're going to win this suit. We haven't got the decision yet, but when we do win the suit, specialists will be able to get national interest waivers. So let me go into both of these things in a little more detail. What happens if you do a PERM application? Because that's what most of our physicians do. So we advertise the job for about 3 months, have to put it in national, like the JAMA or a national publication, and the Sunday, here it would be the Sunday Times, different cities would be whatever the main paper is. And we put in the advertisements, and if we can't find a qualified American physician who's available for the job, you have accomplished the toughest step toward getting a green card. This process used to take 2 years, but now, after the 3 months of advertising, we put in the application online, and usually in 2 or 3 months we have the approval. In fact, one of my paralegals just got an approval in 6 days yesterday. So it is possible to do that. What do you do after the PERM application is approved? Well, your employer will put in a visa petition, and on my slide it says an I-140, because that's the form number. And if there's no backlog in your category, and physicians are in a category that we call the employment-based second category, people with higher degrees, because obviously you have to have more than a bachelor's degree to be a physician. Those are not backed up, except right now they're backed up if you're born in India or China. But if you're not born in one of those 2 countries, there's no backup. So at the same time that your employer submits the petition to immigration, you submit your green card application, which we call in the United States an application for adjustment of status. It's an I-485. And at the same time, you apply for your work permit and your travel permit. And usually within about 6 months to a year, depending on what part of the country you're from, you've got your green card. Now, what if you want to get your green card not through PERM, but through a National Interest Waiver? Remember, you have to work in the underserved area for 5 years. Can you work for yourself? Yes, you can. After the 3 years that you have to work as an H-1B are finished, you can actually go into self-employment. When can you apply for permanent residence? Well, usually, if you're doing a PERM application, you can't put the I-485, the application for permanent adjustment of status, you can't submit that until the 3 years are over. But they make a special exception for people that are doing national interest waivers, that the first day on the job you can apply for a national interest waiver and an I-485. And the good thing about that is not only do you get your green card faster, but your spouse and your kids can also have travel permits and work permits. So a lot of people who want to make sure their spouse can work in the United States decide to go for national interest waivers rather than PERM applications.